Hello, and welcome to the Post COVID-19 Interdisciplinary Clinical Care Network Education Series. This video shares information about advanced care and financial planning. As always, please remember that these educational modules do not replace a visit with your doctor, healthcare provider, or legal professional. Remember to take your time watching these modules. Aim to limit your screen time by watching just a little bit at a time. You are welcome to pause or to look at any videos as many times as you wish or need. Before we begin, we'd like to acknowledge that PHSA provides services to a diverse population, including First Nations, Inuit, and Métis peoples living in various settings and communities across BC. As a provincial network, we operate on the unceded, traditional, and ancestral lands of many Indigenous peoples. We wish to acknowledge with respect and gratitude all of the Indigenous nations, Inuit, and Métis communities with whom we live, work, and provide care. Making important medical decisions, navigating financial and legal issues are common tasks when dealing with a serious health issue or unanticipated event and are a source of great stress for many people. Dealing with these stressors in the midst of a health crisis adds to an already significant burden and can result in increased worry and anxiety, trouble sleeping, depression, relationship problems, weight gain or loss, disconnection from others, problems with memory, concentration, or productivity, or unhealthy coping such as alcohol or drug use, overeating, unhealthy food choices. You are not alone. Many people report these effects. Dealing with stress as much as possible from all sources can help you as you explore possible solutions to these challenges. The good news is there is help available. For more on help with increased stress and its effects as a result of financial, health, or employment challenges, please refer to the Post COVID-19 Education Series Mental Health Modules Number 1 and Number 2, which are available on this site. Today, we are going to be focusing on advanced planning related to your healthcare and finances. We will discuss things to consider as you think about these tasks, how to plan ahead for the many decisions or tasks that might be needed in the event of a possible serious illness or injury. We will review some tools and steps in advanced care, legal, and financial planning, information to have ready as you create your legal documents, where to get help in this process, and we will provide some helpful resources to support you as you navigate your healthcare, legal, and financial issues. We know that discussing serious illness, healthcare treatments, and financial issues can be very stressful and difficult for many. We created this module to support you without judgment, to offer options as you think about your future health and life circumstances and consider advanced planning. As with any legal matter, it is best, if possible, to get help from a professional with legal expertise. Lawyers, notaries, and advocates in healthcare and community organizations can help to make legal concepts and processes clear, create the necessary documents, and ensure legal documents are valid. If paying for legal services is not an option for you, you can create advance plans independently and at little cost. There is help available. We encourage you to access the resources we provide for guidance regarding your unique needs and situation. Some of these tips may apply to you and some may not. The information provided has been chosen because these programs have benefited many people dealing with COVID-19 and other health conditions. We are hopeful you can find resources that are also helpful for you and that this guides you to the places where you can obtain important information and ongoing support. As capable adults, most of us very highly value our health, independence, and autonomy. As we are consumed with daily life and the people and activities that bring us joy, we may sometimes even take these things for granted. Considering that something unplanned may happen that affects our health and our abilities is not often top of mind, especially if we are healthy and well. Today, we want to discuss the importance of thinking and planning ahead for uncertainty. Wherever possible, planning for uncertainty can help to lessen the stress and hardship of unexpected financial, legal, or personal and healthcare matters for you and your family. Most importantly, it is strongly encouraged to prepare ahead of time for when you may not be able to manage these tasks for yourself. This process of planning ahead for a potential serious illness or injury is known as advanced care planning. Advanced care planning is a process of reflection and communication. It is a time for you to reflect on your values and wishes and to let people know what kind of health and personal care you would want in the future if you were unable to speak for yourself. Making sense of the advanced care planning process and legal tools involved can be confusing, complicated, and intimidating. We would like to by telling you about the steps involved and important tools that are a part of an advanced care plan. The process of advanced care planning can be broken down into 5 easy steps. First, think about your wishes and your values about life, quality of life, and how you wish to be treated, about the types of healthcare interventions that are acceptable to you. Next, learn about different medical procedures that are common in cases of serious illness or injury or related to any chronic health condition you have. Thirdly, decide who is the person you trust as your substitute decision maker. This is the person who will share your wishes with healthcare providers and provide consent for healthcare interventions. Discuss your wishes with your substitute decision maker so they know what is important to you and what choices you would make if you were awake and able to speak or direct your own care. And the last step is to record your wishes for your chosen healthcare representative or for specific healthcare in a legal document. Ensure it is kept in a safe place and your named representatives have copies or know where to get them. Your representative cannot do what you have asked if they don't have the official document. So, what do we mean by health and personal care? The legal options we will be discussing address matters that relate to your health and personal care. Health care refers to anything that is done to diagnose, treat, or prevent health problems, provide comfort or end of life care, any cosmetic procedures, or anything else related to health. Personal care refers to matters such as where you live and work, your diet, and what you wear. The social, educational, vocational, and other activities you engage in, the people you contact or associate with, and licenses, permits, approvals, or other authorizations of an adult to do something. Collectively, these matters are deeply personal, unique to you, and relate to all of the aspects of your life. For these reasons, this process is one that deserves time, attention, and careful consideration to ensure your wishes are made clear and the people that know you best are involved and informed. First, we would like to introduce you to a number of important tools used to create a well-rounded advanced care plan. The first is a representation agreement. A representation agreement, or REP agreement as it is more commonly known, is the way for you to authorize or approve someone called your representative to assist you in making health or personal care decisions or to make decisions about your health care on your behalf if you are unable to do so. This person, your representative, works with the healthcare team to ensure your beliefs, your personal, spiritual, and religious beliefs, core values, and wishes are known and central during the course of your care. This helps to guide your treatment and the care you receive. This is a legal document. An adult must be at least 19 years or older to make a representation agreement in BC. They must also be capable of fully understanding the nature and consequences of the proposed agreement. In order to proceed with making this agreement, the adult will be asked to demonstrate their understanding and their reasons for creating it. You choose the person you want in this role: a spouse, a family member, or friend. There are two types of representation agreements with distinctly different powers. The first and most common is a representation agreement for personal and healthcare decisions, also known as a Section 9 representation agreement with advanced powers. This document covers any personal and healthcare decision, including refusing healthcare that would preserve life. A Representation Agreement 9 has the broadest powers because it is made by an adult that is well and fully capable of understanding and discussing their affairs in detail and giving precise instructions as to their wishes in the many areas of life covered at the time it is created. A Rep 9 agreement does not deal with the management of financial affairs. For this reason, an enduring power of attorney must also be in place for finances. The second is a representation agreement for routine financial affairs, a Rep Agreement 7 or Standard Rep Agreement. If you are having difficulty managing your financial affairs and are not able to make an enduring power of attorney, this document may be a good option. This standard rep agreement allows you to nominate someone you trust to manage routine financial affairs as well as personal and healthcare decisions. It requires only that the adult express a desire for help with finances, personal or healthcare, and name the person that they trust to assist them with these tasks. It does not require complex understanding of their affairs at the time of completion. As such, it limits the powers and tasks the representative is permitted to perform on your behalf to minor healthcare and routine finances such as paying bills, filing taxes, etc. Despite the options available, it is not uncommon for people receiving healthcare to not have advance options in place. In these cases, a person's healthcare can be guided by a temporary substitute decision maker. This is a trusted family member or friend of significance authorized by a healthcare provider that is treating you to assist with accepting or refusing healthcare and to participate in healthcare planning and decision making. This person is consulted if you are unable to speak for yourself and do not have a healthcare representative or advance directive stating your healthcare wishes. Legislation called the Healthcare Consent and Care Facility Admission Act guides the hierarchy healthcare providers must follow when choosing your temporary substitute decision maker. Steps involved will be to seek out and approach these people from the top of the list down in this order and ensuring they meet the legal criteria for the role, beginning with your spouse or someone in a marriage like relationship with you, your child over age 19 and all of your children are equally ranked, a parent, brother or sister, grandparent, grandchild, anyone else related by birth or adoption, a close family friend, or a person immediately related to you by marriage. When you think about your relationships, it is important to consider who best in this list can fulfill this role. If your first choice is someone who ranks lower on this list, it may clearly indicate a need for a representation agreement. It is also important to note this is a temporary rule that is only required as long as you are not able to direct your own care. As soon as you can do so independently, the TSDM is no longer required. Unless you have later created a representation agreement, this process is repeated for any future circumstance when you are unable to clearly communicate your wishes. Another advanced care planning tool is an advance directive. An advance directive is a written instruction that gives or refuses consent to healthcare treatment at a time when the healthcare is needed and the adult who makes it is not capable of giving or refusing consent. It is used to document specific instructions to be followed, or if you do not have someone to speak for you. These instructions are legally binding, and healthcare providers are obliged to follow your instructions as written, regardless of the circumstances. We know it is very difficult to anticipate what health circumstances you may face. We also know that people's wishes can also change as their circumstances change. This lack of flexibility is one reason why advance directives are less commonly chosen than other tools. Having a clear understanding of your medical condition and treatment plan is very important as you consider your choices. The conversations you have with your healthcare providers can inform your treatment options and decisions. The information contained in your medical records can also help. If you wish to request your records from your hospital stay, specialist, or clinic consultation, you must complete a formal authorization request and submit it to the Health Records Department of the hospital or facility where you were treated. Find this form and information for where to send completed forms at the link we have provided here. Note, a separate request must be made for each setting you are requesting records from. It is also important to know that these requests can take on average 3 to 4 weeks to process, so making requests as early as possible is key. Like any other contract, it is especially important to remember there are a number of rules about how all of these legal tools are made and how they can be used. We have included these resources from the province of BC, where you can find much more information and watch a video that discusses in detail some things to consider and the process of creating an advanced care plan. Both the video as well as the Advanced Care Planning Guide provide clear information and examples of how the tools we discussed can benefit you and your family. You will also hear various people speaking about how this has been helpful for them and the steps that they have taken. Additional resources are provided throughout this module and in the resources section to follow. Now would be a very good time to pause this video and perhaps take a break. When you return, we will discuss advanced financial planning tools. Hello, and welcome back to our advanced planning discussion. Another component of advanced planning deals with finances and legal matters. Here is a quick review of some basic tools used to prepare for issues related to your legal and financial affairs. These tools ensure that a safety net is in place should something unforeseen occur that results in your not being able to speak for yourself or conduct your own affairs, either because you are restricted in some way, unwell physically or mentally, or too sick to communicate with others. The first option is to create a basic power of attorney. This tool allows you to appoint a trusted person to look after your finances at your direction or on your behalf when you are not available. For example, if you are out of the country and cannot be contacted. With increasing technology, these circumstances are, of course, becoming far less frequent than in the past. Powers may be limited to one account or asset, or it may cover all of your financial and legal affairs for a specific period of time. A general power of attorney ends when you become incapable. The result of this is that you will be left without financial management in the event of a serious illness or injury when you cannot act or speak on your own. The second and more commonly recommended option is an enduring power of attorney. This is a legal document that allows you to give legal authority to a trusted person to manage your legal and financial affairs if you are not capable and cannot make your own decisions or need help with decision making. This person is called your attorney. An enduring power of attorney does not cover decisions about health and personal care, so it means you must also create a Representation Agreement 9. Some things an attorney can do for you is paying bills like your rent or mortgage, loan payments, credit card or car payments, doing banking, applying for income benefits such as EI sickness benefits, short or long-term disability on your behalf if needed, managing investments, selling your assets and paying taxes, looking after financial affairs of dependents, or hiring lawyers to defend a legal action against you if you are too unwell to do so for yourself. Without a power of attorney or shared bank accounts, there is no other way to access your funds or your income in a timely way. While this is not necessary while you are well, not having this option can quickly become a problem if you are seriously ill. Some people assume that their bank will give their spouses or family members access to their funds to pay their bills. However, this is not possible without going to court at great expense and delay, typically of 6 months or longer. Dire financial consequences can result in the time it takes to make these arrangements. If you do not have anyone in your life you trust to help with your finances and your financial circumstances are uncomplicated, you can make arrangements with your bank or perhaps nominate a pension trustee such as Bloom Group. Please see the link provided below for more information. The final legal tool in this series is a will. A will is a legal documentation of a person's wishes regarding the disposal of his or her property, assets, or estate after death. Wills can also indicate your wishes for care and custody provisions, financial support such as trusts put in place for your underage children or other dependents, or your desired funeral arrangements and rituals. Because of this, having a will is valuable even if your estate and belongings are modest. The instructions in this document do not become valid until after your death. As with your enduring power of attorney, you must also choose someone you trust to be the person who carries out your instructions and settles your affairs. This person is your executor. Like any other legal contract, it is especially important to remember there are a number of rules about how all of these legal tools are made and how they can be used. For example, some very basic principles apply. To be legally valid, legal documents must be completed when you are well and able to discuss legal matters in detail. Documents must be signed by you, witnessed, following a specific process and rules, and dated appropriately. These requirements can make this process extremely difficult and often impossible in the midst of a serious illness. While there are some circumstances that you can complete documents without consulting a lawyer or notary, it is important to keep in mind this is not always possible or advisable. In fact, there are some situations that require a notary or lawyer's assistance to ensure the legal tool is valid for your purposes. This guide, entitled It's Your Choice Personal Planning Tools, can help to ensure the options you are considering will meet your unique circumstances. Please copy and paste the link we have provided to access the full document. Some people avoid these discussions because they do not know how to begin and may consider it a burden to the people they love. What we know is most patients and families experience a great deal of relief after this process is complete and their affairs are in order. Having a clear plan in place provides reassurance that their family knows what they want and the clear steps to be taken if they become ill. It provides peace of mind knowing legal, health, and financial matters are in order. Family members express they are thankful to know what their loved one wanted and have confidence to guide their healthcare treatment decisions. The most important step in these processes is to have discussions with your loved ones about your affairs and ensure they know and understand your beliefs, values, and wishes in all three areas. This can be difficult, but it is critical to you getting the care and support you want and need. It can help to choose a time when everyone involved is willing and able. It is also helpful to have a number of conversations. First, perhaps introduce the topic and let your loved ones know you would like their help and why. Reassure those involved you wish to prepare for the unexpected, and it is important that they know your wishes and what you would want. Get agreement from your representatives ahead of time if possible, and encourage them to ask questions to help with their understanding. Let them know you want them to have confidence in knowing what you would choose for yourself when the time comes. Just beginning the conversation can be very helpful. Even if you do not know all of the answers right away, it can provide a lot of helpful information to guide your representatives. Continuing the conversation over time is also very valuable, especially if your health circumstances or treatment options change. These conversations will also help you as you identify and name the person that will ultimately represent you and handle your affairs. Think about the person that you trust to be reliable, detailed, and available when you most need them. No, not every person is equally suited to this task. It is important to choose the person who you trust to best represent and honor your wishes, who is able to communicate clearly regarding healthcare, legal, and financial matters, and be detailed, ethical, and trustworthy when dealing with your affairs. It is important to note if your wishes change, you may update or make changes to these documents at any time. Consulting a notary, lawyer, or the resources we have provided from the Public Guardian and Trustee of BC, Province of BC, and NIDIS Registry can help in this process. Simply put, the three most common tools in an advance care and financial plan are a representation agreement, which makes sure the person you choose that knows your healthcare wishes will speak for you if you are unable to direct your own health and personal care. An enduring power of attorney helps to avoid financial problems if you are seriously ill or injured. It makes sure your finances are managed by the trusted person you choose. And finally, a will makes sure your assets and possessions are shared according to your wishes and can also save your loved ones time, money, and potential conflict during a very difficult time. It also allows you to make arrangements for the care and financial support of your dependents. Information to have ready as you begin the process includes valid identification documents such as driver's license, care card, BCID, citizenship documents, your full address and phone numbers, banking information and details of your accounts, assets, and estate, instructions regarding finances, healthcare, your estate or care of your dependents, full names, addresses, and contact phone numbers of your chosen representatives, witnesses, usually two people that are not family who can sign and validate your documents, sometimes on very short notice, information regarding lawyers or notaries that can help, completed consent forms and early requests for release of health information, and completed medical letters from doctors or hospitals where you were treated. There is one important independent resource called the Public Guardian and Trustee of BC that has a unique role and expertise when it comes to healthcare, legal, and financial matters. The role of the Public Guardian and Trustee is to protect the legal, financial, and healthcare interests of vulnerable groups in BC, such as children, adults who need help with decision making, and deceased and missing persons. This can include providing informed consent for healthcare treatment on behalf of those who are incapable and cannot speak for themselves, who do not have an advanced care plan in place, who have no willing or available temporary substitute decision maker, or when there is disagreement between family members that cannot be resolved. It can also include administering estates of deceased and missing persons who do not have a will. Wherever possible, these tasks are best handled by someone you choose, as there are often long delays and added fees associated with settling estates when there is no valid will in place. The public guardian and trustee also responds to concerns about financial abuse, neglect, or self neglect of vulnerable adults. We know it can be difficult to know how to help an adult that cannot manage their own affairs. If you or someone you care about needs help, contact the PGT as soon as possible. We have included their toll-free number here. Public guardian and trustee staff members are skilled in dealing with these situations and will listen without judgment. Their role in these cases is to determine if and what kind of assistance the adult may need and to help the adult to access that help. Your identity will remain confidential and be protected throughout the process. Please see the link we have provided below for more information or to access the website where you can also make an online report. We thank you for joining us today and for giving consideration to this very important topic. In addition to those we have already discussed, here is a list of resources where you can get additional information. As always, your trusted healthcare professional, family doctor, nurse practitioner, social worker, or specialist clinic can offer support. The following organizations offer many resources online and sometimes through direct contact that can help. We encourage you to explore these many options as needed when you are well rested and able.